I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Please have a seat.
Thank you.
Yes, Mr. Moss.
Thank you, sir. Just start by giving us your full name, if you would, please.
Nigel Graham Polglass.
Thank you. Could we have on the screen, please, WHI 509. Mr. Polglass, do we see here on screen the statement that you provided to the inquiry dated the 15th of September of this year?
Correct.
And are the contents of that statement true to the best of your knowledge and belief?
They are.
Just keep your voice up just a little, if you would. You tell us in paragraph 1 of your statement that you're the Chief Operating Officer for the Whistle Group. Is that
Correct.
right?
Correct.
You are also a statutory director of the Whistle Group of companies.
Yes.
And you worked for the company, I understand, for over 17 years.
Yes.
What did you do before that?
I worked for an American business called Ceridian, where I was the UK Managing Director. Prior to that, I worked for the Hayes PLC, and prior to that, I worked at Royal Mail.
Were those also jobs involved in the logistics and parcel type areas?
Royal Mail was,
Yep.
and Hayes PLC was partially.
Thank you. And so, like our previous witness, would it be right that you hold a really quite senior position in one of the big players in parcel management in the UK?
I think that's fair, yes.
With a good knowledge of the industry?
I believe so.
Thank you. You explain a little about Whistle's business in your statement, parcel delivery management. But there are some differences, I think, to Every. You explain that Whistle contracts with customers to provide them with access to a delivery service and the information that they need to use it. But you don't yourself sell goods, nor do you actually dispatch the goods in the parcels. Is that right?
Correct.
And you don't carry out the final mile delivery either, by which we've understood the delivery of the parcels going to the door.
Correct.
So although most of us in the room will be familiar with seeing Whistle's name on parcels, is it an unfair summary to say that in a sense you are a form of middleman in parcels being delivered?
Yes, we are.
Thank you. And you contract, I think, with very well-known names, Every obviously we've been hearing about, but also Yodel and Royal Mail, to do the actual delivery to the door.
Yes, and others.
And again, we don't need to go into the detail of this, but the outsider thinking, well, why is there a business like this? Why doesn't the seller just contract with Royal Mail, Every, Yodel? Presumably, you can extract good prices because of the volume.
Yes, larger enterprise businesses will contract direct with a carrier like Every. Small to medium-sized businesses tend to contract through someone like us because we can get a good wholesale price for the volume of parcels we handle.
Thank you. And you can also assist through IT with the interface of providing the requisite information to the delivery companies and have the IT to help that being done in bulk?
Yes.
Thank you. How then, just in general terms, by way of introduction, does it work in terms of the requirements about how the goods should be packaged and any restrictions that should be imposed on what is sold?
When we sell a new parcel contract to a client, our salesperson will have visited with that client. They will understand what it is that they are shipping or wish to ship. They will understand the sizes, the weights, the dimensions of those parcels, and as a result will recommend to that prospective client the range of carriers that they may wish to use. They don't have to pick one, they can pick multiple carriers if they wish.
Thank you. And presumably within that, some carriers will be quicker but more expensive.
Yes, that's true. There are those that provide a 24-hour service, those that provide anything down to a 48-hour service, some that provide age verification or proof of delivery, etc. So there's a range of services.
And if the system was working properly, therefore, would Whistle get to understand at an early stage in the relationship with a new customer if that customer was intending to dispatch bladed items?
Yes.
You would expect to be told that.
Yes.
And I think you explain in your paragraph 7, we may come on to this in detail later, but you have information set out, I think, in a customer guide, but also a carrier guide, the references for which are Whistle 2 and 3 respectively, information about restricted and prohibited items.
Correct.
Thank you. You go on to explain in your statement in paragraph 8 that for some customers you offer the first mile delivery. Does that mean, in effect, that you will arrange for the parcel to be picked up from the person who wants to dispatch it?
Yes, first mile collection. Yes, we will collect directly from a premises. A company could bring the items into us, or they may have sufficient volume for the carrier to collect directly from the premises.
And might Whistle badged lorries do that, or would that be Every doing that first mile collection?
Typically it's Whistle, but it could be any of the carriers that we contract with if the volume was suitable and the terms were right for them to do the collection.
All right. Now, I'm sure that there are potentially several days of lectures that could sit behind this, but I want to keep it reasonably simple and understandable. But can you, it's paragraph 9 of your statement, can we have it on screen, WHI 9, page 3. Can you just help us to understand the basics of the information technology? So you start by saying, as part of the setup of any new customer, a link will be created between the customer's order management system and Whistle's carrier management system. What does that mean in real terms?
It means that when a seller of items has sold an item on its order management system, it is at the same time choosing the carrier that it wishes to use to send the items, and it links the order management system to the carrier management system such that they can track the parcels through the network. Our carrier management system will link with our carriers, whether it's Every or others, and therefore a tracking of that parcel to its delivery point can be managed.
Right. So does, let's use Ruar Music as an example. Do Ruar Music, who will come on to, when they have a system, they have some orders that have been made online and they have data in relation to that. Are they providing that data direct to Every, or are you the interface that you suck up that data and you provide it to Every, or is it something else altogether?
No, it's being fed into us to produce a label for the parcel for it to get to its destination. We feed that information then through to every or another.
Thank you. So your IT, your software, is taking the requirements of your client, but who may be the seller, and is translating it to every to create the labels, and your software then gets that back to the seller. Is that how it works?
Yes.
And we'll come on to how it would work in an order like AR's in due course, but presumably that is a highly automated system.
Yes.
But one in which if you wanted to have visibility of that data and do a human eyes-on check or run AI tools on what the content was, you could do so.
I'm not a technical expert, but I would have thought that was correct, yes.
Thank you. So, should we understand that it is the customer, your customer, in this case Rua, who then physically has the label produced, that the IT will give them a label which they can physically print out and apply to the packages?
Yes, there are variances to this, but yes.
Thank you. In relation to that, I think you say in your paragraph 9, is this right, that for domestic shipments, the data for delivery is just the name, address, and contact details for the recipient. Is that right?
Yes.
But I think in relation to, as we'll come on to, international packages, there also needs to be the requisite customs information, which is in the form of a product harmonized code.
Yes.
And our previous witness, I don't know if you're listening, was able to indicate that that's quite granular, so would have a code for several types of knife.
Yes, I did listen to his testimony, and yes, he's correct. There are thousands of codes, and they're used worldwide.
Thank you. But what you are then passing on to every, in this case, would be just that quite limited data about the name, address, and contact details for the delivery.
Yes.
And do you have any fundamental disagreement with the way in which Mr. Ashworth characterized it?
No.
That really, in terms of packaging information, what the package contained, matters of that kind, by the time it reaches every in this situation, they are doing little more than a taking from A to B?
That's correct.
But in terms of the interface that Whistle provide, it also allows for the tracking of the parcel by the customer.
Correct.
Thank you. Against that background, then, please, the delivery of the machete that was ordered by AR. We're reasonably familiar with this by now, but the supply chain, would you agree, appears to be that Hunting and Knives, trading as Agio, entered into an agreement with S.J. Henderson Fulfillment. You're now aware of that.
I'm aware of that, yes.
That S.J. Henderson Fulfillment shared a director with a linked company, Rua Music, and Rua Music had a contract with you, Whistle, yes?
Correct.
It was that contract that was used, and the carrier that was chosen was Every.
Correct.
As we've heard, in the eventuality, there doesn't appear to have been any warnings on the package that it was a bladed item.
No.
No warning on the package that it was for 18 plus.
No.
And no age verified delivery.
No.
Is it common practice to have a supply chain that's complex like that, or relatively complex, for a delivery of this type of parcel?
It can be complicated, but typically, and as we anticipated with this contract, our expectation was that we were contracted with Ruach Music and were handling the items that they had shown us that they handled, which were items linked to guitars.
Can I ask about that? And obviously we'll be asking Mr. Henderson in due course, but did that make a difference for you? You've talked about you would visit the customer or get to know the customer in terms of what their expectations were. We'll ask Mr. Henderson about what the exact arrangement was, but if he had two businesses in neighbouring or adjoined premises, and one was a fulfilment business and one was a guitar business or a music business, and he's contracted with you for the music business, does that make a difference to you? Are you concerned about that the parcel fulfilment side of the business was being channeled through the music business?
I'm not aware that at the time we knew that Mr. Henderson had an alternative business within the premises. Our contractual relationship was with Ruach Music, and it was our expectation that the items that we would be receiving would come from them, not from another part of the business.
I follow. Can I put it this way? Obviously what has emerged is the delivery of a knife in an inappropriate way. If that had not emerged and you had just learnt as Whistle that Mr. Henderson was putting parcels from his fulfilment business through his music business and the contract with you, would that have been something that terminated your relationship so far as Whistle was concerned?
It may not have terminated the relationship, but we would want to understand what it was that was going to be sent from the other, if it's another premises, I don't even know if it is, but we would want to know the type of goods that were coming from the fulfilment business that Mr. Henderson owned.
Because what? If you are contracting with a bricks and mortar music business or something which is an online music business, you know exactly what's likely to be in the parcels, whereas if there's a fulfilment business with lots of different clients, you're open to greater risk as to what might be in the parcels?
Yes, and we would like to understand the impact it has on the volumes, the sizes, the weights, the dimensions of the parcels.
But would those be the principal concerns as opposed to safety and risk of what might be being carried?
Well, we have restrictions and prohibitors on items that we will carry. If we identified that there were items prohibited by us or restricted by us, we would want to arrange either suitable carrier for the delivery of those items or not take them at all.
All right. Can I deal with that? I was going to come on to it later, but let me deal with it now. We have been told, and I think you would accept, that every have never and still do not do age-verified delivery.
That's correct.
From what you've said, presumably for lawful knives, do you have couriers who you can use to
Yes.
take knives?
Excuse me. Yes, we do. So we would use alternatives like DPD or raw mail.
Thank you. So if I could take the example of kitchen knives, is that something that Whistle is prepared to arrange the delivery of?
Indeed, we do.
Yes. What about hunting knives, survival knives, knives of that kind?
Well, we prohibit anything that is a weapon. So maybe that's judgmental, but if we thought that something was going to be dangerous, we wouldn't want to carry it.
So if it was a survival knife that is lawful to sell in the UK, but which can only be sold to those over the age of 18, where there are all the restrictions, 18 plus needs to be marked, bladed item needs to be marked, it needs to be an age-verified delivery. Is that something which Whistle will carry or not?
We would carry items that was using the appropriate carrier that met all of the legal requirements of that parcel being delivered. If it was, as in the case here, if we knew that there were machetes, we wouldn't have even started a contract.
Well, I was going to ask about that. Machetes is a line you won't cross, is it?
Well, I mean, I don't know what all the different knives are, frankly.
No, but you know what a machete is.
I know what a machete is. No, we wouldn't carry a machete.
You wouldn't carry machetes?
No, not knowingly.
Thank you. If we look at the data then that was generated in respect of the parcel, WHI 507, thank you. I think that, can you confirm that this is the data that you would have received about the parcel?
It looks like it, yes. Yes, I think this is one of our exhibits.
Thank you. We see the postcode is part of the information, but there's no request on here for any special instructions for delivery, is that right?
No, none have been added, no.
And there's nothing about what to do if the parcel was, if nobody was at home, and no instructions about leaving the parcel or not leaving the parcel.
I'm sorry, I didn't catch the first part of your question.
There's nothing here about special instructions if somebody is not in,
No.
whether the parcel could be left.
No.
And obviously, had Whistle known that it was a bladed item, it would be inappropriate for it to be left in a safe place where anybody could collect it.
Completely, yes.
I think you deal in your 28B that this gives information that's no doubt important to the system, but not for our purposes, but things like the product weight of the parcel. Is that right?
Correct.
Thank you. And the product information is just listed as drop ship order. My screen has just... Thank you. Drop ship order. Do we see that there?
I can.
And what does that signify?
Well, I know what it means, but it's not relevant to our processes.
Yeah. So just explain what the drop ship process is, Dave.
A drop ship is where a fulfillment company in this circumstance is acting for a seller of the product. The item has been sold. It comes into the fulfillment business pre-wrapped. All they're doing is putting a label on and sending it out. So it doesn't stay in your warehouse.
It's not being warehoused, it's in and out.
In and out.
Hence the drop ship.
Yep.
There's also, I think it's further along in column AJ, there's also is the single word reference, I think, to Agio on this spreadsheet, which you deal with in your statement.
Yes.
But at the time, would you have had any understanding about what Agio was?
No, none at all.
Thank you. That can come down from the screen. You tell us in paragraph 31 that your records show just in excess of 30,000 items, I think, sent by Ruark Music through Whistle. Is that correct?
Yes.
And on your figures, the figures for Mr. Martinez and others vary slightly, but I'm not going to go into that. But on your figures, of those, 2,563 had that reference of Agio.
Yes, that's what our records show, yes.
And you tell us in paragraph 31 that for early shipments, the item was identified as for metalwork, but then, similar to the one I've just shown you, thereafter it just said dropship.
Correct.
Can I ask, please, about evidence from Mr. Henderson, who says in his statement, I'm just going to read it, we don't need to bring it up on screen, that our records show that in March 2022 there were 22 separate orders containing 23 products which were shipped by Agio to the S.J. Henderson facility as one consignment. And Mr. Henderson says that he accepts that the description, he can now see that the description for those products included knives. So if we could have it on screen, it's RUAM 506. We saw this earlier this morning, but I should show it to you. And although it's cut off in the relevant column, we know from the nature of Mr. Martinez's business and the items that Agio Hunting Knives sold, that those look like they're all, or certainly the vast majority, are knives. Now, what Mr. Henderson has said in his statement about that is that, as well as that information coming to Henderson's, this information was provided by Agio for the purposes of onward shipping, and Whistle, as the nominated courier, would have received a record of this description on its system. Is he right about that?
Quite probably.
And it follows, if that's likely to be correct, that at least in the sense that this data was transferred to Whistle, in one sense you were on notice that at least this consignment contained knives.
This is a field within the information that on a domestic product we wouldn't refer to.
Yes.
If this was going internationally, this would be required and referred to.
Yeah.
But domestically, this is not a part of the information or the data sent to us. It's not something that we would, for our purposes, have referenced.
I understand that. But my question was, in one sense, you were on notice that this consignment contained knives, because as a company, you received data that listed it as such.
I can't deny that, yes.
But to be fair to you, I think what you're seeking to explain is that in the multi-million parcel delivery business in which you are involved, that would not be data that would be scrutinized, first of all, by any human being?
No.
In the ordinary course of business?
And what, sorry?
In the ordinary course of business?
No, it wouldn't, no.
And because everything, would this be fair? Please tell me if it's not, but because everything is highly automated, you don't in fact need to do anything with this information, and you wouldn't have expected this, knowing how the operation works, to lead to anything.
Correct.
So does it come to this, that if somebody for some reason had cause to look at this, it would have run alarm bells? Yes?
Correct.
But what you are telling us is you think it's reasonable in a highly automated system that nobody did scrutinize this, notice it, or do anything about it?
Well, it's one of the suggestions which we may come to of how we might be able to improve things in part. Because we would not scrutinise this, we would produce a label If we were told that the item needed age verification or any other particular requirement, we would have to deal with that. But this information isn't asking us to do that. It's just a product description, and it's not something we reference. The label is produced by the other information and goes through the automated process.
Thank you. So if it were to be suggested that there was a failure on Whistle's part because nobody did notice this or scrutinise it, what would you say?
Well, I can't deny the data is in our hands. So plainly, I would like to think that we could have done something with it, but at the time, and it's just not something that we would have even referenced. It wouldn't have been pulled out of the information at all.
Thank you. And you helpfully and proactively raised the thinking about the future in terms of the product harmonised code being used more widely. I think that's what you were referring to a moment ago.
Yes.
Yes? We'll come back to that if we may. But is there the potential where you are receiving a product description to have a IT, whether it's AI or some other form of software solution, that actually runs a simple check for red flag words against the type of delivery? So if an item has a product description of knife, but your system is showing no age verified delivery, couldn't there be a tech solution to that then flags a warning?
I'm sure that's possible, yes.
Is that something you're prepared to look at?
Yes.
Thank you. That can be taken from the screen. I think it follows from your evidence, but I should ask you to confirm that Whistle didn't have any direct liaison with Agio or Hunting and Knives?
None at all.
Or Marpassi SL?
None at all.
No. So far as you are aware, did Agio Wholesale, Hunting and Knives, or for that matter, Henderson's, including Ruar Music for these purposes, did they ever do any kind of spot check, actually testing whether the Agio deliveries were being age verified?
Not that I'm aware of, no.
You tell us that having received the inquiry's request, that in paragraph 15 you've carried out a search. Oh no, forgive me. I'll leave that if I may. Forgive me. Yes, I think it's paragraph 31. You have been able to check that no further deliveries involving Ruar Music or Agio appear to have been made to the same address for AR.
Yes, we can only look by postcode, which will be something like 15 or 16 properties.
Yeah.
And I guess 3 or 4 people per property. So we can say that there was none more to that postcode.
Thank you. The scale of the problem, though, in terms of being able to confirm that 2,563 of these packages were delivered through you, of which I think all but one was through Every. I think one was through Yodel.
Correct.
The scale of the problem is that all of those you now know should have been age verified with product labelling warnings.
I'm assuming that's the case, yes.
Yeah. Mr. Martinez told us that over 99% of these packages would have had bladed items.
Right.
You've got no reason to contradict that.
No.
And overall, in terms of what happened in the supply chain here, would you agree that that's deeply concerning, that over 2,500 bladed items have been dispatched to UK addresses, that all of which should have been age verified, and probably none were?
Yes, I think it's very worrying, yes.
In paragraph 32, looking at AR's individual parcel, I think due to your own data retention policies, the photograph that would have been taken to prove the delivery has not been retained.
That's correct.
But the data which I put to our previous witness in terms of when it was shipped and when it was delivered, the latter being more important, 9:51 on the 26th of October 2023, that data I think was retained by Whistle.
Yes.
So that's paragraph 32.
Thank you.
But I think it must follow that, it's not a criticism of you, but I think it must follow that neither you personally nor Whistle can help with the question of to whom that parcel was actually handed. You can't say what person received it.
No.
Turning to your relationship, your contractual relationship with Every, you tell us in paragraph 11 that that began in 2005, is that right?
It is correct.
We can leave aside the change of name, I think, for Every for these purposes. And you will recall me raising with Mr. Ashworth the contract which Every say was governing the relationship between you and Every from October 2023. And in your paragraph 12, I put it to Mr. Ashworth, you say that that contract was unsigned, it hadn't been agreed by October 2023, which is the date of the machete delivery, and in fact it was never signed, and is this right, so far as you're concerned, that was never formalised into an agreed contract?
Correct.
Do you consider that the relationship was therefore being governed by some previous contract?
Yes.
You don't dispute, it's clear I think from your evidence already, you don't dispute that Every had made it completely clear that they didn't accept age-verified delivery.
I've no doubt about that at all.
And so is the dispute between yourselves and Every in relation to this whether there had been entered into a contract which had a formal warranty that Whistle would not send parcels that contained bladed items?
The contract would have not been signed for numerous reasons. It wouldn't have just been about this particular item. We knew for 20 years that Every didn't handle bladed items. We knew that they didn't have an age verification. None of that had changed at all. And through our guides and our links to their websites, it made it very clear that that was the case. So the dispute on the contract wasn't about whether they were now handling or not handling blades. We already knew the answer to that.
Yes.
So there were other matters related to the contract, typically more about liabilities and a warranty, in this case, that we would know what was in every parcel.
Yes.
Self-evidently, we can't warrant that.
Yes. And it's really that I'm asking you about, because it may be that if there were trivial aspects in this contract with which you disagree, Mr. Polglass, that you wouldn't have been so clear and firm in your statement that you dispute that this was the governing contract. And for the purposes of the issue in which the inquiry is interested, it is a point of difference that you don't accept that Whistle had a formal warranty from you that you wouldn't send them packages with bladed items.
That's correct.
And two things arising out of that. Albeit you would no doubt say it was done innocently and in ignorance, if that was the contract governing your relationship, you would have been in these circumstances in breach of the contract in having a package that was given through you to Every that contained a machete?
That would be how I would understand it, yes.
And secondly, as I put to Mr. Ashworth, you are two of the big players, big hitters in this market. It might be suggested that it's somewhat surprising and perhaps somewhat concerning when one's dealing with knives that you can't agree between the two of you what your contractual terms were.
Well, that contract was, in fact, never signed. We are literally, as we speak, negotiating a new contract, and we hope to be able to find a suitable route through that.
Yes, but you understand that Mr. Ashworth's evidence, again, I don't suppose that the inquiry will seek to get to the bottom of this as a contractual dispute, and that's not really, I'm not asking really who is right and who is wrong. It's more this. Mr. Ashworth says, well, we negotiated this, although it's not signed. It ended up being agreed. And you say, no, that's not right. My question to you is, as big players in this market with responsibilities for the packages that you are sending, both of you, it is might be thought surprising and concerning that you can't agree between the two of you whether or not this was a contractual term.
I think that's a fair assessment.
Thank you. I mentioned in an earlier context the guidance that was given. Can we have on the screen, please, WHI 503? This is the whistle carrier guide. And can we go within that, please, to page 12? And I think it's paragraph 3.3 that we'll need. So it's the responsibility of the customer to ensure these requirements, this is dealing with prohibited items, dangerous goods, and restricted items, are adhered to, and to check whether or not an item is prohibited, dangerous, or restricted before dispatching on an Every service. If items are identified by whistle or our carriers, please refer to our domestic fully tracked customer guide. And then it says, for further detail, refer to the carrier link. And then it gives Every's link to what I can and cannot send. And are you familiar with the fact that that guidance, when you follow it through, the Every what I can and cannot send lists knives in terms as an item that can't be sent?
Yes.
And again, just looking at practicalities, this is something that would be available and provided to, in this case, music, is that right?
Correct.
The purpose of having a link which they need to click on and consult rather than including the list in the guidance, why is that? Is it because it allows them to update their guidance?
Exactly.
And do you consider then that the link is a sufficient means of putting your customers on notice of the Every prohibited items list?
It is updated on a regular basis, and it is, as I say, the responsibility of the sender to be able to make sure that they're using the appropriate carrier for whatever goods it is they're dispatching. Do I think that we could improve upon this? I think we could remind our clients more frequently than we do today.
And is that something that you're now looking to put right?
We've started it already.
Thank you. Thank you. That can come down from the screen. So far as your contractual relationship with Ruach Music is concerned, can I just ask you some questions about that? You've dealt with the fact that you didn't have any relationship with Agio at all, and that it was Ruach Music who sent it. And I've asked you some questions about that. The contract, can we look at WHI 504? can I just let you familiarise yourself again with this document, Mr. Polglass? Can you see that that appears on its face to be the contract between Mr. Henderson's music company, and if we go down and look at the second half of the page, we've redacted the signatures, but it's signed on behalf of Whistle, yes?
It is, yep.
Thank you. So if you now go to page 9, and this should be Schedule 3, and if we can look at paragraph 2, I think quite literally the fine print, first of all. Let me read the relevant parts. Whistle does not accept, and the customer must not require it to collect or deliver any items which are prohibited by any law or any regulation or code of practice. Just pausing there, a machete in the UK would not be as such prohibited by law. There were restrictions, but it's not a banned item. Would you agree?
I would.
Or which are subject to dangerous goods legislation, or which are prohibited on any prohibited items list in Whistle's customer guide, Whistle's restrictions, and so on. So just dealing with that language, was that intended to capture things like hunting knives and machetes?
Yes, I believe so.
Would you accept that the generic description of dangerous goods legislation is ambiguous because it's not necessarily clear whether that is referring to things like explosive substances which may be completely banned, or things like knives that just have age restriction and labelling requirements?
Yes.
And one thing, and I'll be corrected if I'm wrong about this, but although there are many helpful exhibits that you've provided in short notice, I think the specific prohibited items list that's referenced here, that's cross-referenced here, is not within the exhibits. Again, I've touched on this already, but were knives and machetes clearly and expressly contained in a Whistle prohibited items list?
Yes, I'm fairly certain that we have provided the prohibited lists and restrictions list for Whistle.
What did you understand the terms to be in relation to knives?
There is it tries to, as clearly as possible, identify the knives that can go through a process and can be delivered within the UK using the appropriate carriers. And it highlights, I think there's 5 or 6 items on a prohibited list. I can't remember what those 5 or 6 are off the top of my head, I'm afraid. But I'm certain it's within the evidence that we've provided. It was one of the links.
Well, if that can be supplemented in writing in due course to clarify it, if it's our error for missing it, then we will happily accept that. But you think that the effect of it is that some knives could go through. You've mentioned kitchen knives is something you're quite happy to carry.
Well, there are bladed items.
Yes.
So we work with, for example, a very well-known household goods company. Within their items, they have food processors that have bladed items within the food processors. Those go on a separate contract with DPD for age verification.
I'm going to stop you there because we're not so concerned. It's a useful example, but one understands food processor, sharp blade. But kitchen knives wouldn't be on your prohibited list.
No.
Because you've already indicated that you're prepared to have those within the packages that you're the middleman for.
Correct.
So do you think that you had a prohibited items list that somehow drew a line between kitchen knives and hunting knives and machetes?
I believe so, but without looking at it, I can't remember what's on the prohibited list, but it does include, it refers to weapons. Now, that may be subjective.
Yes. Can I ask you about that? One person's weapon is another person's survival tool. Would you agree?
Yes, look, we do everything we can to abide by the rules and legalities of what we do in every respect.
Forgive me, I'm not asking you at this stage about unlawful items, all right? But would you agree that it's very important for Whistle to be clear about what you will and will not carry and what is and is not prohibited as a matter of your policy?
Well, I believe we do, but we're not seeing it at the moment.
Thank you. And the weapons, I think you accept, is open to an element of interpretation.
Yes, although we do provide a list.
Thank you. And to a certain extent, though, you would, trusting Ruan Music, to ensure that they abided by your prohibited list and every's prohibited list.
Absolutely.
Is there any obligation or responsibility, short of a legal obligation, do you think, on Whistle to run any checks on what is in the parcels? I don't mean by opening them necessarily, but to interrogate that to some extent,
Well,
by way of spot check.
we do that through the process of the sale. We also do checks on the company. We do those through Companies House and through HMRC. We will check on the parcels as best one can. I can't open parcels to check what's inside them. There's no reason at all for us to have believed at the time, or indeed now, that Ruat Music would be sending anything other than what they had told us they were going to send.
Thank you. Just want to ask a little bit on checks on the parcels themselves and the packaging. Again, should we understand it that to be your evidence that in terms of the age-verified delivery requirement and the packaging requirements on that, which is your 18 plus and your bladed item, that the responsibility of that would be for the seller to declare that that is the type of item that they are sending and to ensure, therefore, that the right type of label was applied for?
Absolutely.
And because the evidence suggests in this case that the label that would be applied would be a standard everyone, without any of that, you would accept that the labelling for this item was not compliant with the legal requirements?
I would.
In some ways, it's a hypothetical question because the evidence tends to suggest that there was no 18 plus warning on this package. But if an age verified or 18 plus label was applied, but what has been booked through you is a standard delivery, do you have any processes that picks that up?
Most of our process is automated. So parcels come in bulk, they get moved across the shop floor or the warehouse into the large parcel sorters. An item moves around that and is back out, maybe not in the 2 minutes that Every suggested, but certainly within an hour or two would be back out and going off to its delivery point. For us, that may be Every, maybe Yodel, maybe DPD or others. Sorry, I've lost track of the question you asked me. I'm sorry.
So it's whether there would be any way of picking up that there was a mismatch between what was on the label and the type of delivery that had been booked.
It would have to be a very attentive person within the warehouse, I think.
Thank you. So Ms. Wakeman, with her usual efficiency, thinks that not a whistle exhibit, but one from Mr. Henderson. Could we look at RUAM 509, please? Thank you. And could we look at page 13? Is it sharp objects and bladed products? Is that the relevant? So in accordance with the Offensive Weapons Act, and then part 3, it gives the law, and then prohibited sharp objects like knives, kitchen utensils and gardening tools may only be posted if they're packaged appropriately so that they are no risk to employees, other packages or recipients. Any bladed article which is or has a blade and is capable of causing a serious injury to a person which involves cutting that person's skin. Can we just expand that so we can see the whole page again? So those are all services. So what's the effect of that?
I'm sorry, I don't understand your question. What's the question?
Well, so you said you thought it was clear from the whistle restricted items list or prohibited items list, and it's been exhibited, in fact, by Mr. Henderson. So the prohibited item is sharp objects and bladed products. Services, it says all. Description is what's in the middle column, and then exceptions and restrictions. And it says prohibited sharp objects like knives, kitchen utensils and gardening tools may only be posted if they're packaged appropriately, so they are no risk to employees, other packages or recipients. So that seems to be saying package them safely. And then it says any bladed article which A, is or has a blade, and B, is capable of causing serious injury to a person which involves cutting that person's skin. And that says exceptions and restrictions. So is that, I'm just not understanding at the moment what the ultimate effect of that is in terms of what can and can't be sent in terms of blade.
Well, we're trying in, I suppose, a few words to provide guidance on what can and cannot be sent via us. We also have, if there is any doubt still in the sender's mind, we have a customer service team which we highlight clearly in all of the implementation that we have with a client, that if they have any doubts at all, they should contact them.
Just give me a moment. Give me just one moment. Would you accept, on the basis of what's on the screen, well, of course, in the real world, I understand, so you have to do it in a short space of that's understandable, but would you accept that that guidance is not particularly clear in terms of where you draw the line in terms of knives of what can and can't be sent?
I accept that it could be clearer, yes.
Has that been changed since?
We have reviewed all of our training, all of our contractual terms, and all of the exhibits that we've shared with you to improve them wherever we can. Some of those things have already happened, like the training, for example, and others will happen within days or so.
Right. So has this prohibited items list been changed or not?
Not yet.
Right. And you said you wouldn't allow machetes, but if you were the sort of person who thought that a machete was a gardening tool, you might think that was okay.
Well, even if you did, you'd still have to package it correctly, and then you would have to use an appropriate service and carrier to deliver it and have it age verified.
Yes, of course. I'm not disputing that for a moment. But as a company that presumably wants clarity on its policy as to what you just can't send, even a machete, it might be difficult to understand whether it comes within the first half, when it's a gardening tool, that it's packaged carefully and I'll send it age verified, or whether it comes under the second part, where you see any bladed article which is capable of causing a serious injury. I mean, the average reader might just not understand whether that's something you permit or not.
Well, I've already accepted that there's some ambiguity in it. I still accept that point.
Thank you. Can we turn to your helpful section on reflections, which I said I promised that I would come back to. You flag up here at paragraph 34B, it's your page 10, WHI 509. Having made the point that for those lower down in the supply chain, you're only as good as the information that's supplied higher up, you say that at present, this is paragraph B, at present it is only mandatory to include a PHC description in a shipment if it is be sent outside the UK. An improvement to the process would be for the PHC to be provided for all parcels and for that date to be included in the data that goes into a shipping labelled barcode. That would enable the machines that sort parcels to be set to reject certain PHC descriptions. Those rejected parcels could then be handled manually to make sure that they're handled according to the requirements for that particular product, yes?
Yes.
And I think you would have heard Mr. Ashworth's evidence about this, that for every, that would be a significant change requiring a few months, but he thought that for sellers across the country, that would be a major change that would have a long lead-in time. Do you agree with that, or would you have a different analysis?
He's a technical expert, let's accept. I'm not. Do I think it might take a lengthy period of time for everyone to be able to change the requirements within their systems? Experience tells me it would. Whether it's 1 year or 4 years, I literally couldn't answer. We could make this change relatively quickly. I think Mr. Ashworth also highlighted that every could make that change relatively quickly, but it is dependent on the sender to have changed their systems so that it is included within the label. If it's included in the label, we, every and others, can all have our automation look for the description, the PHC, and it can then be diverted into a manual sortation process. So whilst I can't say at all how long it would take to get to it, it is something that's possible. We all do it currently for international goods, so it is evidently possible. There may be some cost, there may be some time drag, but it is definitely possible to do. It does absolutely require senders to use the correct codes and not put in some sort of miscellaneous product code. But if you assume that many people would want to be honest about what they're sending, it would highlight it and it could be diverted in our system and in other carriers' systems.
Thank you. I'm not going to go through them. You set out helpfully, and again in quick time, a number of the changes that have already been made in your statement. Your statement will be published, so they'll become public. You've indicated during the course of your evidence that there are some things still in train and some things which I've raised with you which you will think about. Mm-hmm. Would you be prepared to give the learned chair an update in writing by the end of October?
Absolutely.
In relation to those further changes, improvements and thinking?
Yes, absolutely.
I'm just looking to my left to see if there are any questions. Yes.
Good afternoon, Mr. Paulglass. I ask questions on behalf of the families of the other child victims. You say in your statement, para 34B, that a failure by a party higher up the supply chain to provide the data that's required has a domino effect. What do you mean by domino effect?
If the information at the first touch point, let's say the seller, does not tell us or the carrier supply chain that an item requires certain or special treatment, none of us will know. That's what I mean by domino. So if it's not done there, everyone falls over.
In that context, you said earlier it's the sender's responsibility to ensure that they're using the appropriate carrier for the goods that they're dispatching. In this case, did that responsibility sit with S.J. Henderson, with Agio, or with a combination of the two?
From my perspective, it sat with Ruach Music.
Overall, is it fair to say that you have to take it on trust that the sender is not attempting to send bladed articles via a means which isn't subject to age verification?
Yes.
Is it fair to say that that's a system that relies heavily on honesty on the part of the sender?
Absolutely.
Your statement makes clear, and you've explained in your evidence today, that following the Rule 9 request from the inquiry, Whistler's identified 2,562 items which were delivered by Every, apparently sent by Agio, and arranged by your company. What steps has Whistle taken to establish how many of those deliveries contained bladed items?
We can't find out what was sent in those boxes without asking the sender of the items. I have not contacted Mr. Henderson to ask him that question.
In light of the information that you now have about those 2,562 items, does Whistle intend to take any other steps?
Absolutely. We've provided a list of some of the things that we have already changed or are in the process of changing. We have arranged and already had meetings between ourselves and Every to see whether there are things within our supply chain that we can alter. We intend on doing that with all of our carrier partners over as quick a period as we possibly can. And I would expect from that there will be a series of recommendations that we can make to ourselves and start to carry out, or indeed make back to the chair of this inquiry.
Thank you very much, Mr. Paulglass. Thank you, sir.
Thank you, Mr. Kew. You've dealt with this very quickly, Mr. Paulglass, in terms of responding to the inquiry's requests. You've given very helpful evidence this afternoon. I'm very grateful to you.
Thank you.
You're now free to go.
Thank you.
Thank you very much.
So could we take just a short break, maybe just 10 minutes?
10 minutes.
Stephen Henderson, please.
Yes.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Please have a seat.
Thank you.
Just start, if you would, please, by giving us your full name.
Stephen Henderson.
And can we have on the screen, please, RUAM 5 zeros and 3. And I think you could confirm, Mr. Henderson, that this is your statement to this inquiry, dated the 27th of September of this year, so very recent statement, is that right?
Correct.
And are the contents of that statement true to the best of your knowledge and belief?
Yes.
I should perhaps explain this, Mr. Henderson, that the inquiry's knowledge of the involvement of Rua Music and S.J. Henderson Fulfilment only arose through a statement fairly recently received from Whistle, and that the inquiry legal team contacted you only really quite recently. In response to that, it's right that I should place on record that you have responded with a detailed witness statement, which we see on screen, but also with numerous exhibits, and you have flown over at exceptionally short notice from Northern Ireland and cooperated in that way, and we're grateful to you for it.
Thank you.
Mr. Moss, before you carry on, could I ask Ms. Wakeman to email me the witness statement, because this isn't in the bundle
Yes, of course.
that I have in court. Thank you very much.
You tell us in paragraph 1 that you're the director and CEO of Rua Music. Am I pronouncing it wrongly?
Yeah, look correctly.
And also of S.J. Henderson Fulfilment. Is that right?
That's correct.
Those are both UK companies. They're subsidiaries of the Genesis Group Enterprises Limited, of which, if I've understood correctly, you are also director and CEO. Very briefly, why the three companies?
Yes, I started Rua Music in 2014 as a limited company. It was the first business I founded. And in 2019, I founded S.J. Henderson Fulfilment Limited. And as such, I then formed a holding company to then own those two companies to simplify the structure. And if there's any further businesses in the future, they can form part of that group.
Thank you. Your music business, a musical instrument and accessory manufacturer, is that right, and supply?
Yes.
And for the fulfillment company, did that grow out of your music business in some way? Were you doing a lot of logistics to send out the music instruments and accessories, and you thought, well, I can make a further business out of this, or how did it develop?
That's exactly how it developed. I was doing my own fulfillment. I was shipping my instruments globally. And so with this, I was tasked by a local university in Northern Ireland to advise their business students on how to successfully raise a crowdfunding campaign, because I was successful in that. And from that, one of the actual business students asked me to fulfill their orders as well, because I was doing it already for myself. And so the opportunity arose, and I decided then to form S.J. Henderson Fulfilment in 2019, after 3 years of testing that business model first.
You tell us that the fulfillment business has about 70 clients now.
Correct.
And you say in paragraph 7 you've got a team of 27 staff. Is that across your businesses or just in the fulfillment business?
That's just in S.J. Henderson Fulfilment.
And 34,000 square foot across your sites.
Correct.
You fulfilled 185,000 orders for 1.7 million items.
In the past 12 months, yes.
Thank you. I don't need to go through an overview, because I know that you've been able to read the statements of others, and you know that we're dealing with the provision of a machete to AR through the supply chain that I've been asking previous witnesses about, that was in the end delivered to him without age verification. Did you have an understanding at the time, in October 2023, about the legal framework for the supply of knives, in terms of the illegality, first of all, of selling them to those under 18?
In regards to the selling, we don't form part of the selling, so I was not aware of that.
You weren't aware of that?
No.
Appreciating that you're not the seller, was it not important for you in terms of your fulfillment business to have an understanding of what the legal requirements were?
We have quite a vast range of products within our fulfillment centre. There's over 75,000 SKUs, so to understand the law for every one of those SKUs would be quite the task. I myself verse myself weekly on the movement of goods, whether that be customs movement of goods, etc. And that's where I advise our clients on a weekly basis of updates to, for example, GPSR, movements of goods due to Brexit. In terms of the specific laws on the seller's responsibility, I don't verse myself on that.
What, SKUs?
SKUs are product variations, so a pen that is black and a pen that is red would be two different SKUs, for example.
But given that the law prohibits the sale of knives to those under 18, but goes on to provide a qualified defence, albeit for sellers, but that defence has certain conditions, and those conditions involve, can I put it in this way, aspects of the parcel business, because there are provisions about what needs to be on the label, and there are provisions about the delivery having to be age verified. If you were going to be involved in the distribution of bladed items, it would be important for you to be aware of those legal requirements, even though you weren't the seller.
Yeah, so we have a very strict and tight services agreement with every single one of our 70 clients. They all sign on to it. I don't take anybody on unless they signed our terms of conditions, and they don't deviate for anybody. Within that, and you'll see in the evidence as well, as clause 3.1.6 details that it is the client's responsibility to ensure that they are lawfully packaged and readily available for manufacture and sale.
Yes, and I will come on to that. But if you focus on my question, while you put the responsibility on the seller and they warrant that they will follow the requirements of the law, you would want, as a responsible parcel management company, to have at least an understanding of the legal requirements so that you could spot if things were wrong. Would you agree?
I would agree if I saw something that was wrong or something to draw my attention to the fact that there was something moving through my facility that would warrant different treatment.
Yeah.
However, with this client, there was nothing to detail that to me or my team.
So, for example, the requirement for the labelling to specify 18 plus and to specify on the label that it required an age-verified delivery. Were you aware of those requirements?
We weren't obliged to actually fulfill that for the client. We were never tasked with that.
That is not, forgive me, you must listen to the question.
Okay.
And you must seek to answer the question that I ask. I'm not asking about whether it was your duty to do those things, because the legal duty was on the seller. But I'm asking you, as somebody who was involved in the fulfillment of the delivery, whether you were aware in 2023 that for knives they had to be packaged saying 18 plus, and they had to be packaged saying age verified delivery if they were being sold by an online retailer.
No.
And in general terms, did you permit or prohibit altogether knives coming through your fulfillment company?
As part of my statement, the only time we were notified on our system that there were knives processed in our facility was on the 9th of March 2022. From there was absolutely no indication that there was anything.
But that wasn't my question again. I want to understand, as a company, did you do what Every did, which is just say, we don't do age-verified delivery, we won't touch knives, we don't want to be involved in that at all, or we're prepared to do that, you tell us that it's a knife, you ensure that it's age-verified, you follow the law, but we will be prepared to fulfill the onward transmission of knives. Where did you stand as a company?
Yeah, I stand by our terms and conditions, which would be in line with our couriers, which is the term prohibited items. So if the goods are prohibited, that term stands on its own 2 feet, and I would say that has to be in sync with our couriers.
I follow. So, having prohibited the items as you understood it, you didn't know about the legal requirements on sellers as to how they were packaged.
No.
Did you know that they required age-verified delivery?
No.
You weren't aware that sales of knives had to come with an age-verified delivery process?
No.
In your statement, you explain in paragraph 8 that the overwhelming majority, more than 99%, the service you provide included, in layperson's terms, an element of you warehousing the goods for a period of time. Yes?
Yes.
And you go on to explain that in paragraph 9, a small minority, 0.19%, was dropship products. Is that right?
As a company as a whole, yes.
And what that involved effectively was this, that clients would get to you the items already packaged, yes?
Yes.
Ready to be sent on,
Yes.
and the dropship indicates that all that you are then involved in is effectively not warehousing them, not storing them. You get an appropriate label applied to it, and you onward ship it very quickly.
The shipping label applied, yes.
Yeah. And with Agio, they were one of those in that minority in that they were providing dropship type of delivery.
Correct. The entirety of their operations was that model.
Thank you. And where it is dropship, as I've understood your statement, they will have a label on it, is this right, which will marry up with the data that they've provided. So they will have something on, and we've seen a photograph which may come to, but they will have the name and delivery address and certain data that will match up with what's been sent electronically to you.
Yes, they would detail the name of the recipient and their full address on the pre-packed parcel that come into our premises. They would have already uploaded the order to our system detailing the contents of the parcel, where it was to be shipped to match that. And then we would simply click the button, create shipment. It would spit out then the shipping label to go on to that pre-packed parcel.
All right. And can I just check, in the case of Agio, you've provided a helpful example of it, would you then remove their label and you just have the shipping label, or would their label remain on it?
We would put our label over the top of their supplied label.
Thank you. In relation to the drop ship business that you ran, is this right, that the company who is acting as the seller, who is your customer, they could provide detailed product information or a description of the documents, but that wasn't required. They could just say dropship.
Correct. They also have the ability within the manual upload process to detail conditions, requirements, instructions to our operatives and to our team, which would pop up on the screen under packing notes and delivery notes. They also had the opportunity to upload documents or labels, for example, to the portal, so as when that order was to be shipped, those documents would automatically print and the operatives would be detailed on the screen as to how to act with those. In none of the 2,810 orders that we shipped for Agio, that did not occur.
So no special instructions about delivery requirements or anything of that kind at all?
None.
Thank you. Looking at matters now with the knowledge that you have, with the benefit of hindsight about what happened here, do you think that that's a bit of a weakness in the vulnerability of the system, that the seller, your customer, can drop ship items where the only product description of what they're sending is drop ship?
I believe there is a better way to do things now in hindsight. Now, being part of this investigation for the past 7 days, I understand how we cannot simply trust our services agreement and trust our clients to comply. It's evident that that is not enough, and we have to take extra measures to make sure absolute truth is detailed on our systems.
Thank you. And if you now, I appreciate you've not had much time, and no one can criticise you if you haven't yet changed it, but are you going to change things so that customers have to give more detail?
I already have. As of Monday of this week, an email went out to all of our clients detailing the new process, which will follow suit with the 99.81% of our business, which is all SKUs product details have to be fully disclosed and detailed so as we can break open the contents upon arrival and check the contents, warehouse the items for later sale, and then we pick, pack and dispatch, and that will ensure that movement cannot take place ever again.
So
Would you share that email with the inquiry?
No problem.
Thank you very much.
Thank you. So far as your contract with Agio is concerned, you explain in paragraph 12 of your statement that you entered into an agreement with Agio, who we think of sometimes as Hunting and Knives, on the 18th of February 2022. If we look at HKAW 4034, please. So this is the services agreement, and we see S.J. Henderson fulfillment at the top. We can go to page 3, please. And if we could look at point 2.12, have that paragraph. S.J. Henderson does not accept any of the following goods for storage, fulfillment, or dispatch. No liability should arise in respect of them. Goods which are or may become dangerous, hazardous, noxious, explosive, radioactive, or damaging. Firearms is next. Goods prohibited by law or regulation of any government or public authority of any jurisdiction where the goods are carried. Goods which S.J. Henderson deem unsafe or not in a suitable condition. I don't think any of the others are relevant. Now, you mentioned earlier on that you had contractual terms. Would it be fair to say that these do not on their face necessarily appear to completely prohibit knives, including machetes?
It does not detail those items explicitly. I would say at a macro level, it would cover it in relation to the law and the movement of goods, should it be unlawful to move those items.
The difficulty there, I suggest, Ms. Henderson, is that it is not as such unlawful to move those items. Whether or not it's unlawful to move the items depends upon the packaging and the verification process.
Yes.
And so the outside reader of your contractual terms might think, well, I don't think a machete is dangerous as such, and it's not unlawful, it's not prohibited by law. There are just rules about how they can be sent. Would you accept that this clause, if you intended it to be a prohibition on knives and machetes, is not sufficiently clear?
I would say the rest of the terms and conditions would go into more detail as to that.
Well,
in terms of clause 3, explicitly details the client's obligations.
Yes, but that's not the point about which I'm asking you.
Okay.
Clause 3, which I'll come on to, deals with the client's obligation to follow the legal requirements.
Yes.
But this comes back to the question that I was asking you earlier about whether or not you are a company who is prepared to carry knives through the packages that you are involved in. And if the answer to that in knives and machetes is no, paragraph 2.12 does not make that clear, does it?
It doesn't make it clear explicitly, no.
You asked about section 3. I was going to go on to that. If we could look, please, at the bottom of page 3. we see client obligations, and if we go over the page to the top of page 4, we should see 3.16, that the client will comply with all laws and regulations affecting manufacture, sale, packaging, and labelling of its goods. So there you have the point that you were raising, that your customer, under the contract, has the duties for how they are sold, how they are packaged, and how they are labelled. Would you agree?
Yes.
So unequivocally, that was Agio or Hunting and Knives' responsibility under your contract to ensure that the correct labelling and sales type was used?
Yes.
Yes? But as to whether they were permitted to send knives or machetes at all, I think you agree your terms are ambiguous.
I would agree with that.
Again, is that something that you'll look at in terms of clarity in your terms and conditions as to whether you permit knives and machetes to be carried at all?
Going forward, yes.
Thank you. Now, the evidence of Mr. Martinez yesterday, in broad terms, was to the effect that he relied on you, or your company, to ensure that UK law was followed. And when I put to him aspects that he had a legal duty about packaging 18 plus and labelling 18 plus and bladed items and to ensure age-verified delivery, the general tenor of his evidence was he was looking to you to do all the necessary because you were the experts in UK shipping. And he also suggested that at a video conference, although he couldn't point to this being in writing anywhere, at a video conference he thought that that was made clear that you would take care of the labelling and any requirements on the type of delivery service. What do you say about that?
I would say that's incorrect. As evidence in one of my exhibits, we were clearly told to only apply a shipping label. Thank you.
And in fairness to you, although we had it on screen yesterday, can we just remind ourselves, please, of RUAM 505? Bottom of the page, email from them on the 17th of February regarding the shipments. We would like all of them to be sent with a traceable tracking number in order the final clients can track the process. So there was nothing there, was there, about age verification being required?
No.
Do you agree?
I would agree.
And at page 3, sorry, you were right the first time, Sarah. Top of the page, please. Thank you very much. Third paragraph down, towards the end of the third paragraph, these packages could be sent already packed and labelled so that you only have to include the label of the transport agency, and from your warehouse they would be sent to the final clients. So there was nothing there about an expectation on you that you would put some special labelling on to comply with bladed items legal requirements. Would you agree?
I would agree.
Thank you. I want to ask you next about a potentially important topic, which is your knowledge, though, of what the items were. Prior to you receiving the request from the inquiry, did you know, in truth, Mr. Henderson, that Agio were sending knives and machetes through you?
Not until this year.
And you say not until this year. Is that because of the Irish customs find in March? All right. So I should have said before this year. So you had some knowledge of that from the customs find in March of this year. But before that, you say, do you, that you did not know that knives and machetes were being sent?
No.
Could we look at 4 aspects of this, please? The first is that you sent Agio a questionnaire asking about what kinds of products they sold. And could we look at that, please? HKAW 4035. And we should note, in fairness to you, that this is a document that you volunteered. Could we have the main text highlighted, please? So we can see in relation to the questionnaire, I want to focus on question 6 and the answer. So question 6 was, what are the commodities products? And as you've volunteered in your statement, the answer that they gave to that was outdoor supplies. But then these words, we are specialised in knives, yes?
Yes.
And also question 7, what e-commerce platforms do you sell on? Where will orders be processed? And the answer was www.huntingandknives.co.uk. Did you or somebody in your company not acknowledge the significance of that at the time?
The significance wasn't acknowledged, and as part of my investigation for this inquiry, when I read that email, I now was shocked to find that it was right before my eyes in detail.
Because I'm going to use the phrase, even if it's well-worn, missed opportunity. But that was a very clear missed opportunity for you to appreciate that the reality of this was that Agio were a knife seller.
It was a missed opportunity to understand, there was going to be knife movements potentially in those parcels for sure. The highlight for me was the fact that they said outdoor supplies, comma, and the outdoor supplies would suggest it was the primary focus.
Well, you say that, but let's not forget what's after the comma. What was after the comma?
I understand, yes.
What was after the comma?
Well, we are specialised in knives.
Yeah, and what was the website?
Hunting and Knives.
Yeah. Did you look at the website?
I don't have recollection of checking that website.
Do you understand now that it is a wash with pretty ferocious-looking knives?
In the past week, I have visited that website, and I can confirm that, yes.
And we've heard from Every and from Whistle that what they seek to do with their customers is early on understand from them what they are likely to be selling, dimensions, what the nature of it is. If you had got to know in a curious way what the business of Agio was, set out quite openly in outline terms in this email, you would have instantly have known that they really were largely about knives, machetes, swords.
That would be unknown unless the question was asked to Agio.
Yes.
Because the contents were not disclosed to me.
No, but why didn't you ask?
Because of the model whereby they were moving, there was nothing to say on the exterior of the carton that come into us in bulk that there was bladed articles inside. There wasn't an age verification service requested for me to receive those goods.
But had you had any experience of those selling knives and bladed implements previous to Agio?
Sorry, can you repeat that question?
Had you had any experience that other customers of yours, you've got 70 customers, were any of your previous customers before Agio's knife or bladed implement sellers?
No.
No. And you didn't know, you've told us what the legal requirements were around this, even though they would be the ones who had to meet the legal requirements. So against all of that background, when they're saying we're specialised in knives and our website is Hunting and Knives, again, can I put it to you that wasn't just a missed opportunity, that was a moment in time where you should have asked questions.
I should have asked more questions as to the scale, the actual knives in question here. On the same website, you can buy gloves, different other miscellaneous goods. At that moment, now looking back on my investigation of the past week, the law at that time did not ask for courier ID verification service. It did not ask for labelling of those items either.
Forgive me, they didn't ask for those services, and that's why I, to Mr. Martinez yesterday, put a number of challenging questions to him about how they fell far short of their duties.
Yes.
But you should have asked far more questions.
In hindsight, yes, our due diligence has to go further. Our due diligence back around that time would have more been around the company, the liquidity of the company, the directorship, making sure everything was up to scratch on Company's House, more around the finances and the structure of the company. You can see in other correspondence, because they mentioned Grupo Marzpi in Spain, I asked, who am I entering a contract with? Because if Grupo actually owned the goods, I must actually hold a service agreement with both. So my due diligence went along the lines of services agreements and the liquidity of the companies I was dealing with. But I now understand further due diligence should have took place.
Yeah, but a much more simple question would be, goodness me, I'm not quite sure what the law around shipping knives is, because I've never done it before. I'd better find out. Yes?
In hindsight, yes.
Secondly, in March 2022, I think in one of the very early consignments, if not the first consignment, could we have on screen, please, RUAM 506? Again, if the top could just be highlighted. I've read out your statement, paragraph 18, in relation to this a number of times, but I think you accept that on the first consignment, but not subsequently, these product descriptions were given.
On the first consignment on the 9th of March 2022, yes.
Yeah. And although we're looking at a printout of a spreadsheet, so the column is cut off, it's plain from the most cursory reading of that these were knives.
All bar one.
So one of those may not be.
One of them is not.
Fine.
Number 3, as confirmed in my witness statement.
Yep, fine. The others all were.
Pardon?
The others were all knives.
I can see that, yes.
Yep. Did you read this?
This was a download from the system during my investigation in the past week. The nature of the movement of goods, that data is available in the system, but it's not data you work with due to the goods coming already pre-packed, ready for a shipping label to be affixed. Hence, I've removed that model now within the business.
Yeah. So at the time, is your evidence that you didn't read this?
Is there evidence that I didn't read it?
Yes.
Well, I didn't read it.
No.
It's my statement. I'm not sure of the evidence I could provide.
No. Don't worry too much about where the questioning is going. Just listen to the question and answer it. I think your evidence must be you didn't actually read this at the time.
No, I did not.
And would you say that even though perhaps you're a medium-size provider rather than a very large one, would you say that there was no particular need for you to read it because this is part effectively of an automated system?
The fact that I could go in and download this material shows that it was on the system. Can you rephrase that question for me?
You didn't, at the time, have a need to go into the system in 2023. You didn't need to go into the system and read this and manually input it from one system to another or anything like that?
No.
So you're not looking at yourself now and thinking, damn, if I'd done my job properly, I would have read that list and known they were knives.
Yeah, we did not have to work with this information.
At the same time, this was something which meant that the data available to your company would have shown, if it was interrogated, that they were knives.
Yes.
And if from the first missed opportunity you had thought, well, I'd better keep an eye on what they're actually shipping to check that it's outdoor supplies, not knives, the first consignment list would have rung alarm bells.
Yes.
And so that's the second opportunity. The third opportunity, could we have on screen, please, HKAW 4038? I think married to this first consignment, HKAW 4038, Mr. Martinez says that along with the product description, there was also this type of information. Could we just try to highlight perhaps just the bottom left 2/3 so that we've got the imagery of the items and through to the column. That will just about do, I think. And can we see that although one may appear to be a set of scissors, you just about work out that there were images showing that they were knives, yes?
On our portal, yes.
Yeah. And so if we go to the top of the page, please, can we just highlight the text in the top left-hand side? That's SJ Fulfillment Limited, and that's your portal.
Correct.
Yeah. And again, does that mean that that data would have sat somewhere on your system?
It sits amongst those 75,000 SKUs, yes.
Yeah.
On that page, there are 10.
So again, Whistle in particular have explained this to us, that they would have a large volume of these and no need to read them individually. But as a third opportunity, this company was providing on the first set of sales imagery showing that it was knives that they were selling.
I wouldn't be able to say yes to that or no to that because I'm unsure when these images were supplied. They don't have to have an image. Certainly, they would have submitted the information to the system detailing these contents absolutely as confirmed in that CSV upload. The images, I am unsure if they were present at the time or not.
I don't think it's suggested that these were sent every time. I think the suggestion from Mr. Martinez in his witness statement is that these were for the first consignment.
Yeah, it absolutely was not for any movement following 9th of March for sure. Everything was detailed, simply drop ship from there on in. For the first movement, again, I can't confirm if there were images detailed or not,
but
because
again,
products can be edited.
But again, if you had been alert, if your antenna had twitched by that questionnaire at the start and you'd wanted to check the early consignment, it looks as though, would you agree, as well as a list of the items and product information with images was also sent and was on your portal?
I would say that definitely for the CSV spreadsheet for sure, and I would say that would give me enough information to warrant a search.
Thank you. And then could we have on the screen next, please, RUAM 508. And could that be rotated, please, anti-clockwise, Sarah? And could we enlarge the bottom parcel? Again, this is I should make absolutely clear, Mr. Henderson, is a exhibit which you have volunteered, and it's helpful to the inquiry, especially given the pressures of time that you are under. This appears to show how the packages would arrive into your unit. Would that be right?
Yes, this was sent by one of the employees of Grupo Marzipi before it left Spain, the very first original consignment.
I follow. So this is taken in Spain, showing how it would look. And we can see, consistent with your evidence, minimal data on there: name, country, postal code, city, address, phone number. It's got an Agio Wholesale Limited address in the UK. But it has also got HK, the logo for Hunting and Knives, and the full name, Hunting and Knives, yes?
I can see that logo at the top left, the HK, and Hunting and Knives written underneath that in small letters, yes.
Yeah. And I think you would agree that in excess of 2,500 parcels of this kind came through your facility all probably labelled in this sort of way with hunting and knives.
Yes.
And that was also, would you agree, a repeated missed opportunity for you to realise the likelihood that what Agio were doing was using you to convey knives?
It would be from the photographic evidence that I received again within that email thread. There's nothing to indicate following that first movement if that logo continued to be represented, given that there was such a change in how they were submitting orders to us from the 9th of March 2022. I'm unsure why they done that change. There's no, upon my investigation, I cannot see correspondence to suggest why they made that move to manual input, detailing dropship only, no further comments.
So you can't, as you sit there now, say one way or the other whether the label remained the same for all of them. But whether it was on this first occasion when they'd answered the question, specialise in knives or outdoor equipment, we specialise in knives, and our website is hunting and knives. If this was the image that they sent you, this is how we're going to send things through to you. Again, it's plain on its face, isn't there, that there was a really significant issue here, putting you on notice that the likelihood is that these packages were going to contain knives.
Again, this was an image sent to me over email here, and this is zoomed in substantially. So the hunting and knives is barely readable. I understand there's a logo there. I do understand as part of that same email chain, which I have already commented on, that I should have done more on terms of actually a further due diligence checks now in hindsight. But given the nature of this image being sent to me in this format, it's the detail how the packages are to come into our facility.
Do you regret now not doing more and not being more curious and not asking more questions?
Yes.
Are you sure that it is not the case that you knew all along that these were knives?
I'm sure I did not know they were all knives.
Thank you. In terms of your understanding so far as the packaging is concerned, I think that we've dealt with most of that. But can I ask you this? Was there any sense in which at any time you asked questions about the appropriate labelling above and beyond the standard shipping label? You didn't go back to Mr. Martinez and ask the question whether they required any special labels?
No.
And presumably, as with previous witnesses, the fact that over 2,500 of these parcels, all of which should have been age verified, and all of which should have had labelling, and none of them did, presumably you now find that both a very serious matter and very worrying.
Absolutely, and that's why I'm here today.
Thank you. Was there any process that you had for running any kind of spot checks on what your customers were sending? Did you dip sample from time to time?
As we both referred to earlier on, 99.8% of the movements are all booked in and checked in. You're going by the description on the outer case. As I'm sure you can appreciate, we cannot break the seal of boxes and check contents, therefore certain products cannot then be sold. But what we do is check the description, scan them in and book them in. So that forms part of the checks. We facilitate over those 1.77 million items. They all were booked in that format, the 99.8% of that. And the rest were drop ships. Because the drop ships are pre-packaged, for people who have already ordered these, the client has already sold the goods, they've packaged them. I deemed it not appropriate to break open these to do any checks.
Thank you. In terms of the couriers that were then used, we know that Whistle was the one that was usually used, and that I think with just one exception, for the Agier parcels. Were you aware that Every didn't have an age-verified delivery service?
I wasn't aware of that. I also wasn't aware of the need for a business to have an age verification service because I wasn't aware of the contents of the goods, nor was I ever asked to use that service. Should we have been asked to provide that service, I absolutely would have asked all of my courier networks, do you offer this? And would have provided that service.
Thank you. Can I ask you about the arrangement that was made? Because your contract with Whistle, which I think is how you carried out the fulfillment of what Agier wanted, your contract was with Ruar Music, your music business, who had a contract with Whistle. So you were channeling your S.J. Henderson fulfillment packages through Ruar Music. Would you agree?
For the Whistle movement, yes.
Yeah. Why were you doing that?
In November of 2020, Whistle approached myself. They called me, and there's evidence to detail that, to offer their services to my fulfillment business. In January, following that, in 21, they then made a proposition to Ruar Music Limited, and that was because Ruar Music was in business for longer. So they said we could secure better credit terms and fulfill orders through that business. So therefore, we could invoice across the sister companies for that purpose. So from the very beginning, Whistle were aware that they were dealing with a fulfillment company for third parties.
So you say that was cards on the table, they knew all about it?
Absolutely.
Again, I may be corrected if I'm wrong, but I don't think that we have seen the emails around that. Are those things that you could provide to the inquiry?
They are part of the exhibits. I hope they did come through because I submitted those.
All right, well, we'll look at that.
Yep.
But in any event, what you say is that there was nothing hidden, no subterfuge about that. You were playing with Whistle. In fact, they had suggested to you that you could add your fulfillment business on the music company account, effectively.
Yes, and the timeline matches that.
Thank you. Is it right that Whistle have now terminated the agreement with you?
I terminated the agreement with Whistle about 6 months ago, and they never responded. So I have heard, I read as part of their statement that they have stopped supplying services to us, but I had already terminated the contract 6 months ago.
And why had you terminated the contract?
Simply because none of our clients were using their services anymore. They didn't find any services that they wanted to use and had moved to other competitor companies, mostly down to financials. They weren't competitive anymore.
Thank you. Do you agree that so far as Whistle are concerned, in their contract with you, they did have terms in their contract and in their guidance which referred to prohibited items, so that if you followed the link to Every in particular, there was a very clear prohibition saying Every don't take knives, full stop. Would you agree with that?
Following the link to Every, yes, I would agree with that. But in terms of Whistle's terms and conditions, I don't believe they are in sync with Every's because they don't strictly prohibit the movement of knives or bladed articles. I refer to my evidence from the Wayback Machine that I utilised.
So if we can just pause there, we just have on your screen paragraph 20 of your statement, RUA 503 at page 6. I think this is the bit of your evidence you're referring to. My understanding is that it is and was Whistle's policy that knives or bladed items are not strictly prohibited, Rather, they're permitted provided that the sending party complies with any additional requirements relating to them as set out in their prohibited items section. Is that right?
Correct, and you can see what I have inserted from the 22nd of October 2020. Would have been a month before they first reached out to me, what their website detailed in relation to those objects.
What did you understand that Agio were actually sending in the parcels? What was your understanding about that?
My honest understanding was outdoor supplies, and that there was nothing to be cautious about due to the contract we held with them, which I understand now to be, we were very reliant on that contract and reliant on the goods coming into our premises appropriately labelled and with instructions should we have to take extra precautions. So there was nothing to alert me to that.
But in terms of your contractual obligations with Whistle, and what they were saying in their terms, they were indicating it's the customer's responsibility to choose a carrier which will carry the goods, follow any particular requirements, and to notify us of the carrier of any special instructions for handling and delivery. Now, obviously, you would say that you were onward dependent upon Agio, but would you agree in terms in which here every didn't permit knives at all, that was another reason why, if you were in any doubt at all, you should have checked with Agio what these packages contained, because it was only your assumption that it was outdoor equipment.
Our clients indicate the courier services they want us to use. They actually select it themselves, and in this case it was a manual upload to our system explicitly detailing the service to use. Now, upon its investigation, there's more work to be done to actually forward information and actually find information online for our clients so they understand the various restrictions across all companies in the UK that they have access to utilise, so as they understand the restrictions and the requirements.
Thank you. But certainly so far as Whistle is concerned, you were the customer and they were putting the responsibility under the contract on you to ensure that the requirements about avoiding prohibited items were met. So it's not a complete answer to that, is it? To say, well, Agio should have told me, because that creates, would you agree, an obligation and a responsibility on you to ensure that what is being sent doesn't breach the prohibited items list.
This is why we have a services agreement with each of our clients, because it does put the onus on the client to ensure they oblige, because it is their business. They are the one who are selling the goods.
So what, Mr. Henderson, was your responsibility? What was on your shoulders, if anything?
My responsibility was to ensure they upheld the services agreement.
And did you ensure that?
I believe extra measures can now be put in place to ensure it.
Yeah. What's the answer to my question? At the time, did you satisfactorily ensure that your client upheld the service agreement, or did you fall somewhat short?
I believe that model of the dropship that we're discussing here today allows for the client to not disclose sufficient information for me to do my job on that front, given the fact that there's 1.77 million items, doing searches.
So the system allowed Agio not to disclose things. But I'm focusing on you, Mr. Henderson, and your responsibilities, because you're part of the chain. And you had contractual obligations to Whistle, who also put you on notice about every's requirements, and your responsibility to ensure that the prohibited items list was not breached. So can I ask the question again? Did you do all that you should have done to ensure that your client upheld the service agreement, or did you fall somewhat short?
Looking back, I would say I fell somewhat short.
Thank you. In terms of the termination of the contract with Agio, I should cover that, but I'm going to do so relatively briefly. Could we just look at your paragraph 24, please, on page 7 of your statement? So that's RUAM 503. Thank you, and it's page 8. Oh, sorry, you were right first time, forgive me. Yes, page 7. You got a notification from the Irish Tax and Customs about the seizure of one of the Agio packages, is that right?
Yes.
Can we have on the screen, please, RUAM 4010? We just note the Republic of Ireland crest at the top left, and it's from the Republic of Ireland revenue. But if we can look at the main paragraph of text, please, just enlarged. Notice is hereby given that certain goods, to wit, one Joker lock knife, one chicken machete, one Bowie type knife, one Muella dagger, one bayonet type knife, one butterfly knife, 6-barrel pepper box revolvers, 3 throwing knives, one ceremonial dagger, and one Mikel Nita hunting knife were seized by the Irish Customs. Yeah?
Yes.
What was your reaction when you got that notification?
My reaction was entire shock that these were the goods that Agio were trying to send through my facility. They were obvious breach of our services agreement.
Because?
Because of the variety of clauses which I quoted in our email to Agio, clause 2, clause 3, you can see here explicitly a firearm detailed.
Yeah. What Mr. Martinez said about that was that it was a historic replica. Does that make any difference to you?
It doesn't make a difference to me.
And is it your evidence that this was the first time that you were actually aware that the packages contained quite on the serious end of knives?
Yep.
Did you at that time go back, as you told the inquiry you did when you received the inquiry's notification, to look at what you had been told by this company previously?
In terms of doing an investigation?
Yeah, in terms of going back to the email where, when first asked about what items they would be selling, they said, we're outdoor specialists, we specialize in knives, and our website is hunting and knives.
I didn't go back to that email on that day. I put the onus on actually ensuring it was terminated. I went out to the warehouse immediately and spoke with managers to ask was there anything dropped that day or the day before for Agio. There was. I ensured that was set aside immediately and seized. And I contacted Agio to say this will be returned to sender, as in the supplier in Spain. So the onus was on ensuring swift action.
If we look at it at RUAM 4012, could we go to the next page, please? And to the bottom of that page, maybe page 3 then, please. Is that the very bottom? Can we go to the bottom of page 2? So, yeah, that's it. Hello, Stephen. We'd like to have a video call with you if possible tomorrow morning. So, no, forgive me, it's further down, please. Could we go to the whole of that page? Right, so this is an email from you. Dear Alberto, I'm writing to formally notify you that in accordance with our Master Services Agreement, we're terminating our contract with immediate effect. This decision follows the seizure of your goods by customs due to their classification as dangerous goods. which are strictly prohibited under section 2.12 of our agreement. As per the agreement, we do not accept hazardous or dangerous goods for storage or fulfillment. Additionally, under clause 5.2, early termination charges apply following payment of the outstanding invoices. Please arrange for the removal of any remaining goods. If you require clarification, don't hesitate to contact me. So, in fairness to you, a pretty robust immediate termination. Would you agree?
Yes.
And if we go to the preceding page, please. There's a request from someone at Grupo Mapazi asking for a video call to discuss this. We'd like to have a video call, possible tomorrow morning, so we can speak about it. We have a long, good working relation. Sure, we can find a way to solve this without ending our contract. Top of the page, please. Let's go to the preceding page right at the bottom. Previous page right at the bottom. So the page before that, please, right at the bottom. So the email out starts, "Hi Tanya," and then top of page 3, please. Unfortunately, you have left us liable for prosecution. Is that because you're concerned about the firearm in particular?
The gun led me to, yeah.
The goods being shipped to us go against our terms. We cannot proceed further trading with the noted goods. Please furnish your account with full payment and remove all stock on our premises. And if we go to the previous page, can we have the whole text of that email, please? Thank you, Sarah. I'm surprised you do not, and this is from Mr. Martinez. I'm surprised you don't even want to talk to us about what happened, and you do not inform us of which article you've told is dangerous, nor have you sent us any kind of documentation. As you well know, we send cutlery, and this is not classified as a dangerous article for transport. And then he purports to give the UK's guidance on shipping dangerous goods. On the other hand, I was very upset when you sent us an invoice for the termination of the contract. You've unilaterally rescinded without giving explanation. Merchandise in your warehouse is valued at £10,000, not to mention the damage you're causing us with respect to our clients. And then he threatens legal action against you. Your reaction to being told we send cutlery, I think if we go to the next email, so that it would be on the previous page, is evident from the response that you sent. Dear Juan, thank you for your email. I understand your concerns and want to clarify the situation. You're always welcome to book a call with me using the link, etc. But to address your concerns, I can confirm that the seized goods were not cutlery. Customs flagged and detained the shipment due to its contents, which included lock knives, bayonet knives, butterfly knives, pepperbox revolver, throwing knives, daggers, hunting knives. And then you refer to those clauses. What did you make of Mr. Martinez's suggestion that what he had been sending was cutlery?
I couldn't believe it. It was very obvious to me that he was evidently still trying deliberately not to disclose the contents of what he was sending inside his packages, and it infuriated me.
In a sense, it may be that you've answered my next question. Obviously, it will be a matter for the chair in due course, but as somebody who was in business with Martinez, at least to this extent, what was your assessment? Did you assess that he was somebody who wasn't on top of the law and wasn't on top of what he was shipping and was making errors? Or did you think that this was deliberate concealment?
It's hard to draw parallels based on the limited email correspondence that I've had with that individual. As you know, I've dealt with Alberto mostly, not Johan. I'm not sure at which side he sits.
Did you report the company to the authorities in any way at that time?
I responded to the customs authorities, and they said they were going to respond to me with further detail and action. Nothing further was reported.
What was the nature of what you said to the Irish customs authorities?
It should be detailed here in the evidence too.
Well, just give us the outline of it. Just give us the outline.
I told them I was terminating the contract with immediate effect. I supplied them with the same copy of terms of agreement that you have, that I had with Azure Wholesale. Confirmed that we didn't own the goods and the legal liabilities of the client.
So you effectively said that it was their responsibility, you were terminating it, they weren't your goods. And did you say you didn't know that these were the items that they were shipping?
Correct, and I asked them to dispose of the goods.
Thank you. In terms then of looking to the future, reflections and lessons learned, your statement to the inquiry had a section in relation to that. Can we bring it up, please? It starts at paragraph 39. It's on page 13. I'm not going to read out all of this. As with previous witnesses, you'll understand your statement will be published, so the totality of what you say. But in effect, you start in paragraph 13 saying you have 70 active clients, receive warehouse and fulfill orders for them, and over the page, you have strict service agreements in line with the couriers we subcontract, in this case, Rare Music. And in paragraph 40, it's the responsibility of the account holder with Whistle that any items it was asking Whistle or Every to deliver were not prohibited. Paragraph 41, during the preparation of the reference shipment, visual inspections of the packaging were conducted as standard to confirm alignment. Paragraph 42, Whistle placed responsibility on the customer to ensure parcels comply with their policies. This is the same approach taken by other couriers we use. At S.J. Henderson, we have strict service agreements with our clients requiring them to send only goods which comply with Clause 2. And then it comes to this in paragraph 43. In this case, we were not informed by the client Agio that the goods fell outside of our service agreement, nor were the parcels labelled confirming the contents included bladed items. Therefore, we had no way of knowing that the parcel contained a machete other than unpacking every sealed parcel and checking the contents, which is not part of the service we provide. Accordingly, the client failed to comply with our contract, which resulted in Whistle's terms and conditions being breached without our knowledge. So throughout those paragraphs, it might be thought that you were saying in terms that this failure was solely the fault of Agio and Mr. Martinez.
Yes.
Paragraph 47, you say, to our knowledge at the time, S.J. Henderson fulfilled an order for a client who, as per the terms of our signed agreement, bore full responsibility for understanding and complying with their legal obligations. You go on to give the detail in relation to that. And then you say this, about 5 lines from the bottom of paragraph 47. Accordingly, I believe that there was nothing different we reasonably could have done. With hindsight, however, and now with a clearer understanding of how the client undermined our contract, misrepresented the contents and used our fulfillment centre to process this order, I am implementing changes to reduce the potential for such deceit in the future. As a direct result of this case, we are strengthening our internal processes. All right? Mr. Henderson, that wording, accordingly, I believe there was nothing different we reasonably could have done. Do you wish to change that evidence and that sentiment in light of the areas that I've explored with you?
Well, this speaks to the individual parcel to AR. It was a response to a question that was submitted to myself. It details that on the paragraphs previous to that. That's what these paragraphs are in relation to. So based on that parcel coming in that format, not correctly labelled, without the the client actually asking us to send it via Courier ID verification service, not detailing anything underneath the packing instructions. There was nothing further we could have reasonably done at that time.
All right. But it's just this, you see, repeating the thanks for the speed with which you've dealt with matters and acknowledging that you haven't had long to reflect on these matters. Nowhere in the reflections on events, in response to a request for you to give your candid reflections, do you say, we had some missed opportunities to recognise that these were knives and we could have done better?
At a macro level, I would agree with that.
Thank you. I'm just looking to my left to see if there are any questions. Ms. Henderson, thank you. Those are my questions. So do you have any more questions for this witness?
Just one, Mr. Henderson. You'll remember a little while ago, Mr. Moss was asking you about communications with Mr. Martinez. And the position is that the inquiry heard from Mr. Martinez that he claimed that he had a video conference with you and that during the course of that video conference, you said that you were the expert in relation to matters such as age verification and the delivery of parcels that required that kind of condition attached to them. Firstly, early on in your relationship, were there any video conferences between you and Mr. Martinez?
Yes.
Were. Secondly, during the course of those video conferences, was there any exchange of the kind that I've just outlined?
No, and to speak to that Zoom conference, I do know I had one off. The emails that we have looked here today that specifically told us to simply apply a shipping label was emails that followed that Zoom call. In that same thread, I say thank you for your time on Zoom.
Right. Was it just one Zoom call early on then?
From my investigations, yes.
Right. And you don't have a memory of there being more than one?
I don't recall any more than one.
No. That's so helpful. As Mr. Moss has already said, Mr. Henderson, you have responded to the request from this inquiry with truly impressive speed. I think you've only known about this for about 7 days. And the fact that you're here today and you've provided all the documentation that you have is something for which I am very grateful.
Thank you.
Thank you for evidence, and thank you for attending, and thank you for your help.
Thank you very much.
Does that draw a close to this afternoon?
That's our evidence for today. We don't have time to start Mr. Ali sensibly. So with your permission, sir, we'll sit at 10 o'clock tomorrow to hear the evidence from 3 witnesses, Hamza Ali, the Amazon delivery driver in relation to the knife, Mr. Boomfree of Amazon, and PC McNamee.
Thank you very much. 10 o'clock tomorrow.